Foss vs. Harbottle case in business law.
The plaintiff in this case were Richard Foss and Edward Starkey-Turton. They were the shareholders of the company. The defendant in this case were Thomas Harbottle, Joseph Adshead, Henry Byram, John Westhead, and Richard Bealey. They were the members of the company. Richard Foss and Edward Starkey-Turton were two minority shareholders in the Victoria Park Company. The company had been set up in September 1835 to buy 180 acres (0.73 kilometers square) of land near Manchester. According to the report, enclosing and planting the same in an ornamental and park-like manner, and erecting houses thereon with attached gardens and pleasure grounds, and selling, letting or otherwise disposing thereof. This became Victoria Park, Manchester. Subsequently, an Act of Parliament incorporated the company. The issue of this case happens when the directors of the company and some other persons had misapplied the company's property. The two shareholders then took legal action against them on behalf of the company. The court held that the individual shareholders have no cause of action in law for any wrongs done to the corporation, and that if an action is to be brought in respect of such losses, it must be brought either by the corporation itself or by way of a derivative action. The reason is the company suffered injury. The company could take action against the person who misapplied its property. Other people outside of the company, such as the shareholders, could not take action against the members on behalf of the company. It is the consequence of the fact that a company and its members are a separate legal entity. In the case of Salomon the Fifth Salomon and Corporation Limited, the court held that Mr. Salomon and the company were two separate entities. Even though Mr. Salomon owned majority of shares in the company when the company went into liquidation, other consequences are limited liability. The company is liable for its contracts and torts. The shareholder and the company's members has no such liability. Only the company are responsible of the action for breaches of contract and for torts which damages the company. This means the shareholder are not liable for the damages of the company. When the shareholder acquires a share, he accepts the fact that the value of his investment follows the fortunes of the company. He can only exercise his influence over the fortunes of the company by the exercise of his voting rights in general meeting. Over the years, the Foss vs. Harbottle became a leading English precedent in corporate law. In any action in which a wrong is alleged to have been done to a company, the proper claimant is the company itself. This is known as the rule in Foss vs. Harbottle.